Larzo?
Yes,
And Mr. Larzo, in cause number 26 DCCR 0770, you're charged with the third-degree felony offense of obstruction or retaliation from March 8th of 2026. Your indictment alleges that you were previously convicted of assault on a peace officer and assault on a public servant on October 12th of 2023, both of those cases on the same day, which means if you go to trial and are found guilty in these cases, or this case, and those prior offenses are true, that means you would be considered a second-degree felony for punishment, which is between 2 years up to 20 years in prison. Do you understand all of that?
you can repeat that for me?
What part of it do you not understand?
The first part,
What you're charged with?
the part where you said.
So here's the thing. You're charged with obstruction or retaliation.
Correct.
The offense date is March 8th of 2026.
Correct.
And that's a third-degree felony.
Correct.
The indictment also shows me that you were already convicted of 2 other felonies on the same day. What that means is if those are true, or at least one of them is true, it would enhance your punishment in this case to a second-degree felony, which means if you go to trial, you're found guilty, the range of punishment is between 2 years and up to 20 years instead of 2 to 10. Do you understand? Sure.
What it says is if you convicted, if you catch the case, 2 of the cases at the same time, then that would be consist of the enhancement. If you put both of those charges at the same time, I didn't catch those charges at the same time, even though I was convicted at the same time because they ran a CC.
Here's the thing, it only matters on one of them, right? Because the fact that they were run CC is what makes this enhanced by 1 instead of turning it into a habitual. So I'm only counting it like it's 1, right? So let's just assume you have 1 prior conviction. It doesn't matter if you have 1 or 2 or 14 from the same day, the same conviction day. It only will enhance this 1 level, which means from a third degree to a second degree, just like I said. Make sense? Okay, so.
I'm sorry to interrupt,
Sure.
if I may.
Yes.
For the benefit of the defendant, I've tendered that pen pack to Mr. Rojas. The convictions are on the same day, but for the actual same type of offense. And in this instance, he threatened to murder a police officer, which is why the offer is what it is. And for his benefit, I also tend to introduce a punishment where available by the rules of evidence, the misdemeanor and juvenile contacts with the law that he has had as well.
All right, guys. Today we are going to witness a courtroom exchange where the stakes become crystal clear within the first few minutes. The judge carefully explains how prior convictions could double the defendant's sentencing range, but instead of simply accepting it, he immediately questions the legal enhancement. Just when the discussion seems technical, the prosecutor reveals a far more serious allegation, raising attention and showing why this case is being treated with such caution. Every word here lays a foundation for the conflict that's about to unfold.
All right, thank you, Ms. Malfino. So you've had an opportunity to visit with Mr. Rojas about your case. And Mr. Rojas, do y'all have an announcement?
Judge, I was speaking with Mr. Larzo yesterday. I think his intention is to come here this morning and ask for a new lawyer. I explained to him the way to get a new lawyer is to reject the offer and set it for trial, because I think that was originally his intention. He, however, didn't want to sign any paperwork with me.
Because I haven't got an offer. You haven't gave me an offer. You said 5-year cap. I don't know what that is. That's not an offer. If you offer me 5 years TDC or you offer me 5 years probation, you didn't say which one. So when I get an offer, I'll let you know. I don't know what the offer is.
Sounds like the offer was a 5-year cap. Is that correct,
That's the
Mr.
offer.
Rojas? And I'm sure Mr. Rojas explained to you what a cap is.
Yeah, he just said I can't get more than 5 years.
Right.
Okay, so what is the offer? How many years? 5 years TDC?
So it's up to me. So if you sign for a cap, and I'm sure Mr. Rojas explained this to you, it's a way for you to try to come to me and say, give me less than 5. I could give you 5, 4, 3, 2, or I could consider probation. It would all depend on the information that I.
Buckle up, guys, because this is where the conversation shifts from legal explanations to real decision-making. The defendant argues he never received a proper plea offer, while the judge patiently breaks down what a 5-year cap actually means and why it doesn't automatically guarantee prison time. It's a crucial moment that highlights how confusion over legal terms can completely change the way a defendant views their options before making one of the biggest decisions of their case.
Man, I'm going ahead. I want to request a new lawyer. He's not representative.
Here's the thing, you don't get to do that. So here's where we are. Mr. Rojas is a great lawyer. He's not, just because
Can I
he's,
speak?
nope, not while I'm talking. I already gave you an opportunity earlier and I'm gonna give you an opportunity in a minute, but I want you to listen carefully to what I have to say first, okay? Mr. Rojas is telling you what the district attorney's office is offering. You don't have to like it. It doesn't mean he's a bad attorney. And another attorney is not gonna come get a different offer.
Okay.
So, Ms. Malfino, is there any reason that you would know of that offer that you have made would change?
No, it will only go up.
So you're where you are. So either you accept that offer or we set your case for trial. Once your case is set for, hang on,
I want a new lawyer. I don't.
hold on.
I
I understand, but
you
listen,
want to let me speak, man? Please, can I speak? Please?
I'm going to let you speak, but I'm going to give you what your options are, okay?
I just want. All I want is a. What I'm saying, you trying to say trial, this and that. I haven't even seen my discovery evidence. You saying he's a good lawyer, but he haven't even shown me no evidence. So on my case, how can you speak and say that he already told me the other day that he working for the DA? He
I'm
already said.
sure
When I said you haven't. He have not one asked me what happened. He haven't even got my side of the story. Have you got my side of the story? Have I told you what happened in this case? Can you tell this person what I told you?
Mr. Larzo, you're not in charge and you're
I'm
not
not saying
asking
I'm not in
questions.
charge, but what I'm saying is, how can he say he can represent me and he's ain't done nothing but come to me and say the DA said this, the police report said this. He has not.
That's the evidence. That's what he's telling you the
I
evidence is
understand
what's in.
that's what the police report said, but he hasn't asked me my side.
And here's the thing.
All right, guys, this is a turning point where the courtroom atmosphere changes completely. The defendant openly challenges his own attorney, claims he hasn't been properly represented, and even questions whose side his lawyer is really on. The judge repeatedly tries to restore order while explaining that a defense attorney's job is to evaluate the evidence before deciding whether to negotiate or fight at trial. What begins as a disagreement quickly turns into a heated clash over trust, communication, and the right to a fair defense.
Is there media in this
Judge,
case?
if, as Mr. Rojas does in every case, he has requested and reviewed the discovery well in advance.
Do you want, let's do this. Do you have some media?
Judge, I have requested the media, what I told Mr. Larzo yesterday, when he told me he wanted to watch the video, I told him we could reset the date to look at
Sure.
the video. He just said he didn't want to do that. He just wanted
Right.
to come in and ask for a new lawyer.
I want to know because you not represent me effectively. You come to me and tell me the DA said this.
Mr. Larzo, he's just said that yesterday he would
I
bring the
haven't-
video. Don't talk over me. He would bring the video for you to watch. I'm going to reset your case for 2 weeks. He's going to bring the information. You can watch it and you can make your decision. The offer is what the offer is. The DA's already said that. I don't care if you take it or if you don't take it. Take it, fine. Don't take it. We'll get your case set for trial. You need to be respectful.
I'm respect-
Mr. Rojas is going to get out there, show you everything. You don't get to keep copies of things by law. He doesn't get to hand you a police report and you keep it. That's part of the law. So he can go over that with you, read what it says to you, show you the video, and then you can make your decision. Go back with the bailiff.
May I ask a question,
Go,
please?
nope, I'm done today. Go back with the bailiff.
Buckle up, guys, because this final exchange brings the entire hearing to its defining moment. The attorney explains that the evidence has already been reviewed and that the defendant was given an opportunity to watch the recordings before making any decision. Rather than replacing counsel, the judge orders more time to review the case, makes the legal process unmistakably clear, and closes the hearing with a firm ruling. Now it's your turn. Would you accept the plea deal or take your chances before a jury? Let us know in the comments below. If you enjoyed this courtroom breakdown, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss another real courtroom case. We'll see you in the next video.